So I thought with all the comments and everything that you guys provided, I hadn't had a chance to get through much of it.
Okay.
But if we want to go back to
Sure.
1500, work through those that you guys
Yep.
sent me, and then we
Yep.
can get on to some more things.
Okay. And I did read through yesterday. It was on my other machine. I was trying to find it. I did read through that attendance policy. We did change that attendance policy, and we did it with Lisa.
Okay.
But I can't find it anywhere. That would have been with Chrissy.
Right. See, and I thought we had as
Yeah.
well, but what I have learned is there's a lot of policies on the board, on the website, that are not accurate.
Yeah.
So
Okay.
we just have to.
Go back through it anyways, because
Yep.
that was driving me crazy. Because after I started reading the language, I thought, oh, wait a minute, we did change this.
Right.
And because we did look at the letter for the 9 days and all that kind of stuff that we were talking about. But okay, and I did read through. You had made some changes to some of this, though, didn't you? The 1500, because
I did. They're
Okay.
in red.
yeah, I thought last night when I think it was last night when I was going back through.
Because I wasn't sure who put the burgundy in, and then I thought the blue was from you. Or
so wherever I had put those comments, yeah, I don't know either. It just, I think because I changed it to suggesting. Let's see, so if I change it to suggesting and I just start typing, I think it automatically, I think it automatically changed it. That's just putting a green line there, so I don't know.
Yeah, it doesn't.
Oh yeah, see, it turned it to green this time.
But it's pink on our.
Yeah, for us.
Oh really?
Yeah,
Oh, it
see?
is. How weird.
Yeah.
Look, see, yeah, it's a green. If I just say,
Yeah, and see, that's I
if
hear
I
you.
t-
Okay.
yeah,
So
oh,
let me
okay,
see.
so maybe maybe that was mine. I don't know.
I don't know. But if we want to just cruise through it, it shouldn't
Sure.
take that much.
Yeah.
We added, or did you add the superintendent? Someone, which is fine. Meeting defined.
Superintendent.
I removed where the line and the insert location
Mm-hmm.
to the boardroom. Regular meetings shall be held at a time and place agreed upon by the Board of Trustees at the annual meeting. The regular meeting schedule shall be posted on the district website. Then I just added Board of Trustees because it drives me nuts when we start with Board of Trustees, but we don't state, so
Keep using the same language.
yeah.
Oh, I see. All the way up at the top, that superintendent. Yeah, I have no idea
Okay.
where some of that came from.
I wonder if we can see.
We should be able to look at the history.
Yeah, I was just gonna. No, make that come back.
Okay, so who did this? Yeah, I don't know. It shows everybody with different, maybe. Oh, it was in. So the original one that we had, it was in there. So
What
I
I
don't
am-
know why it turned it that color. See,
Oh wow.
there it is right there.
Huh.
So I don't know. And then here we are right here.
Oh, that's weird.
Yeah, I have no idea.
It could be that that's when she copy and pasted, or when she
Right,
I
made
don't
the-
know, made the copy of the
Uh-huh.
document. But what I'd like to find out, and I'm not sure where it's at in statute, but I know it's in statute. Prior to COVID,
Mm-hmm.
the law was you had to have,
One person, yeah.
but it had to be a board member. But
Mhm.
then during COVID, they said no, it could be the superintendent.
Yeah.
So is it still allowable to be the superintendent, or does one board member have to be present?
Yeah, that would be, that's open meeting law, might be in the manual.
Well, we haven't gotten an updated manual post-COVID. Here's my little blue book.
Oh, that's the video, I don't want the video. Oops. So I think we're still using the 2018 manual. Let me see here.
So the code says it's been updated as of July 1, and it shows right here. One member.
Of the governing body, or the director of the public agency, or the chief administrative officer.
Okay, so it can be.
Yeah.
All right. I just wanted to make sure it was
Yeah,
in code.
74-203, so do we reference that at the bottom of the policy?
Yes, governing
Okay.
bodies. Okay. All right. Nothing with emergency meetings.
Days prior to its regular July meeting, so that would be a whole month.
Right.
June, we should have those budget hearings.
Right.
It'd be nice if we had, definitions, referencing the definitions, because a hearing, between a hearing and a meeting, because a lot of times people use them interchangeably and they're not. Public hearing is public input.
Are there tissues anywhere?
Yep. Your allergies?
I think so. My sinuses are just nuts
Uh-oh.
right now. I'll put it right here. Thank you.
Something must be blooming through fine for now, but yeah, we're gonna put it right there. I might eat something.
There you go. Under definitions in open meeting law, there is nothing differentiating between a hearing
public
and a
hearing.
meeting. There is special meeting.
So since we're on this, on our website, we have only posted, or that sheet that's the one that you were discussing that's approved.
Correct.
It only goes through September. The sheet, it only has up to September 14th.
That's a
Meeting
problem.
Oh, yeah. So
That's
we need to
not
fix
accurate. Yeah.
Yeah, that should extend all the way past to January until we,
It goes through December.
yeah.
Oh, no, it does post the
Jan-
January meeting,
Yeah,
that's right.
January is when we decide all that stuff.
Right. Schedule.
Maybe if I just search their site. 'Cause everybody uses it, but some of there's definitions.
Okay, well that needs to be, when I scan for it, I guess, would be,
What's that?
well, when I pull up the board meeting schedule in Google Docs, it only goes to September, but what was on the board meeting, because it was on Thursdays, it went all the way through to the January meeting.
Yeah.
So I have no idea why Janelle did this.
So that's in our, those are the approved meetings right there?
We approved them
Yeah.
to be on Wednesday, not Thursday. So
Right.
yeah, so we need to update that and
Is
correct
that
it.
me?
No.
Just wanna make sure. That when I turn my, I didn't turn my
Which
phone
board
off.
meeting is it on?
On January 13th is when we approved it, but the document wasn't on board book,
Oh,
because what was on board book was prepared with Thursdays, and the board decided at that time we want it to be Wednesdays. So we corrected the January, or
The day.
we corrected the day at the meeting to say, no, let's make it, let me go to the next February meeting. I wonder if it was brought forward, or if it was just something she did. Ouch.
January 13th, 2022. Okay, I think I found the hearing definition. I think it's maybe Title 7-1304.
Okay.
Okay, so yeah, it was never brought back to the board. So We need to update that on the website correctly.
So, I could potentially get that PDF and update it, change it.
It's not a PDF, it's a Google Doc. You need to update the Google Doc,
Okay.
convert it to a PDF, and then upload that onto the website.
Alrighty. Update the Google Doc. Convert.
Yeah, and it's
to
20,
PDF.
the title of the Google Doc is 2022 Wednesday board meeting schedule.
Alright.
And then when you list the January date, it needs to be identified as the annual meeting. Because technically this shouldn't have started with January, it should have started with February.
Mm-hmm.
Okay.
So we'll correct that next time.
So let's see, is this actually correct? August 10th? No. So this doc actually is correct. These are Wednesday dates, we just need
Right.
to go past the September.
Right.
Yep. Oh yeah, there's even a blank page after it. Huh.
Yeah, so
I'll
Don't-
send it to you, Rosanna.
okay.
Oh,
So at least that way you can go right to it, because sometimes when you go searching around, you'll find multiple,
versions.
Yeah.
Yes.
and it's like which is which, and
What is the second Wednesday of October? What about November?
December's the 14th. And January would be the 11th.
Okay.
I do not know why I have too much stuff on this calendar. Okay, there we go. Oops. So did you just update it?
I did.
Okay, why can't I? Oh no, I see that. Let me refresh it. Yeah. Oh, now where'd you find that one? See, here's another one, 2022 Wednesday board meeting schedule.
That's the one I just updated.
Well, it doesn't have all that verbiage afterwards. me just
Oh,
close
that's
it.
weird.
Yeah, that's what I'm saying is unfortunately you go searching for stuff and
Yeah, 'cause see, it's the 2022 Wednesday board meeting schedule.
Yeah.
And and it had cause you've got language in red, it had red, but I just Control Alt and changed it all to black. What's that? Oh, that's the old one.
Yeah, see,
Because
that's
what we
the
did-
problem. So we should probably just delete this one. Where is yours saved? And does it say by Janelle?
How
at the
do I
top?
know?
Just go to File, Properties, or
Details.
Details, yeah.
Close clerk chair.
The chair, and then within the chair folder, there's a clerk folder.
No, it's the chair clerk folder.
Oh. Okay. Wherever that is. Chair clerk folder.
Yeah. Do you, let's see here. Where's the, let me go.
Yeah, because this one was in the clerk documents under board meeting schedule.
So
So-
here's the clerk chair.
Okay, so it's just you, so it's in the one that Rosanna has access to.
Yeah,
Okay.
yeah, because I just went through all of the drives that at least I can see, and I had the old superintendent removed.
Clerk, board meetings.
Oh, wow.
So these were all the clerk documents that were being
Oh my goodness.
created.
Okay.
Yeah, and then there's this monthly calendar. Yeah, there's too much stuff. Yeah, so that clerk directory everybody has access to it.
Okay. Yeah, that one should be deleted. And the only reason why I know is because,
Well, we don't wanna delete this clerk documents because this was everything that
no,
Oh.
just the
the form-
duplicate document with the same title. Because we added clarifying, for some reason I know this was brought back to the board,
Yeah,
because I had said, no, I want this language to clarify, because
okay,
it just looks so,
I'm gonna delete this one, just
Okay.
so it won't be, to the trash and, I can't do the trash, we don't have access.
where did it, why is it not here?
Okay, let me go back to this.
Online presence, okay, consent agenda.
This is three, yeah.
Yeah. I don't know.
I got too many windows open. Okay, back to this.
Okay, so on that particular document, Rosanna, do you need me to send it to you, or do you
No, I
understand
found
where it's
it.
at?
I
Okay.
found it, thank you.
Alright, so 1500, okay, what I did was I read the statute on the executive session, And what they wrote, only in the event that the board vacancies and not absences prevent 2/3 majority from being present. That's not in the statute. I mean, those words.
Mm-hmm.
So I just took it from the statute. The information provided shall not compromise the purpose of going into executive session, and when there are board vacancies preventing a 2/3 majority from being present, a simple majority vote to enter executive session may be called.
Mm-hmm.
Because that's in the statute.
The simple majority
Yeah.
language, yeah.
Yes. I didn't appreciate the executive session may be held for and only for. It's like,
Yeah.
no, so we just took that out. And then I've just been kind of going through this statute, and I wanted.
Okay, so, oh no, I guess,
Oh, there's no
I can't tell if
$100.
it's, I guess it was taken out.
What?
The little, whatever that symbol's called, I never remember its name.
Oh, it's the paragraph or the section symbol.
Section, there you go. That's what I was gonna call it, paragraph. But I know it doesn't refer to the paragraph.
Did I?
Is it in there or is it lined through? It's hard to tell right there.
Move your cursor. No, I don't think it's lined through. Yeah, it's not lined
Okay, so maybe that line goes too far. Here, let's
through. It
see.
does.
I'll just take it out. Format that. There we go. Yeah, it was just too close for my eyeballs to see.
I hear
Alright.
ya.
Okay.
So then I was down on item F, and
Yep.
I changed them to the alphabetical letter because that's where they are in the statute.
Okay.
But I can't do lowercase, so it's uppercase. According to Google, that's all they're going to give me.
Oh, really?
Yeah, when I do the
Uh.
drop down, I don't know how to change it. It's above my pay grade. See, they don't offer a little lowercase unless you're,
Indent one more.
yeah, which we could. What'd I do? No, didn't do it.
There you go.
Stop touching. Thank you for fixing that.
So it was up here, it was under the format.
Okay.
Oops. And then, bullets and numbering, and then options.
Oh, perfect. Thank you.
Yep. So there, now you get a pay raise.
Yay. $0 to more $0.
About the zeros.
That's right. I prefer to think about the Benjamins, but that's
Yeah.
okay. Oh, here we are. I need to go. Oops, back over here. To F. I was concerned because
Mhm.
what was stated was to communicate with legal counsel and to discuss any legal ramifications.
Mhm.
It's the statute specific to legal counsel for the public agency.
Mhm.
So I interpret that to mean that if some lawyer wants to come talk to us,
Oh yeah, no.
that needs to be an open session.
Yeah.
So I
Right.
wanted that specified so we don't have that situation where someone's saying, oh no, it can go in executive session. So it's specific to the district and the board of trustees, because the district can have its own legal counsel,
Right.
as can we.
Right.
So I would think that if we're going to hear from legal counsel for the district, it would be an executive session.
Right.
Or should it only be the board of trustees legal counsel? And do we want to limit it to that? Because
Well, I
it says the
think it
public
would-
agency.
Yeah, I think it would have, well, look, we already sort of came across this when we dealt with other executive session issues that didn't stay in executive session.
Right.
And we learned then that, which was a district, legal counsel,
Right.
but also, I think it could be either or, then just depending on
Well, it says public agency, so to me, the public agency is the school district,
Mhm.
not the Board of Trustees. However, the Board of Trustees is a component of the public agency,
Or the
and
governance of
it
right.
has its own legal counsel. So I think it's important to do those.
Mhm.
I don't know who did the blue, the mere attendance of legal counsel.
That was probably
Previous?
from the previous one, yeah.
Okay, so
Yeah, and that's an ISBA,
yeah, just take that.
although I think it actually might say that in the, I don't know if it's in the statute, but maybe in the
What it's
manual.
what it states in the statute is what I added. The mere presence of legal counsel
okay.
at an executive session
Right,
does not satisfy this requirement.
right.
So legal counsel can be at the meetings, because what I didn't like was it's just implying that the attendance of legal counsel at a board meeting.
Mhm.
Well, it's irrelevant. She can come to the board meeting. Doesn't mean we're going into executive session with her
Mhm.
or him.
Mhm.
So the statute specifically states the mere presence of legal counsel at an executive session
Mhm.
does not satisfy this requirement.
Right.
So I just changed that.
Yeah, I remember reading all these. They're sort of confusing.
Did you want these letters to exactly reflect the letters in the legislature? Cause they don't reflect. 'Cause
Well,
there's-
they don't starting at G.
Yeah.
Because G and H aren't relevant to, but that was my intention. I didn't realize there was.
Where is this? No, there we go. And it says a way to get that from Merlin.
Statute likes the word mere.
Meerkat.
Yeah, that's exactly what I was thinking. Um, Okay, so J, which is our H, simply states to consider labor contract matters authorized under section 74206A, 1A, and B. So to conduct deliberations regarding labor negotiations. A. Oh, 206A, okay. Okay, so unless I'm, because
Where you at?
well, the negotiations in open session, I went to 74206A.
Okay.
To conduct deliberations regarding labor negotiations. So the board may still deliberate regarding labor negotiations and may caucus regarding labor negotiations in executive session. This is not accurate. And the reason why,
any of this anyways.
yeah, I know, but I guess I'm trying to understand why we have it there, because that's not accurate. I mean, the board within and of itself wouldn't be caucusing on negotiations.
Well, if we did these types of labor negotiations that they're talking about, we would. Because it would be the board and then the LEA or whomever their representatives. It would be different than what we're doing now. If we did the old way, it would be the board collectively deciding about, instead of doing the bargaining thing like we do now.
The interest-based bargaining.
Yeah, it would go back to how it used to be, which was this.
Except, I guess what my point is, it says, a governing body or its designated representatives may hold an executive session for the purpose of deliberating on a labor contract offer or to formulate a counteroffer. That is the board in and of itself. The LEA is not in there.
No.
Okay.
Right, yeah, no, the board would do.
So
So as it is now, the district has a team and the LEA has a team.
Right.
So the district team in this interest-based bargaining still, and the LEA, there's still been times when we have caucused. We've split apart and we went into a room and they went in a room and we talked about, you know,
Right.
if we thought that was a good deal or not, or
The-
whatever.
But the statute doesn't address interest-based bargaining,
Well, it does.
does it?
Yeah, it absolutely
Okay.
does. It's under the same portion that says that we have to have, that's where the
Okay.
50% plus one
Oh,
blah,
okay.
blah, blah thing. If,
Okay.
that's why I say we don't do this.
Okay.
Although this is part, because we're doing board meetings, this is part of an allowance for executive session. So yeah, the statute does allow for the interest-based bargaining, but it's under another section. So the
But see,
part-
well, I guess what I'm struggling with is
Uh-huh.
what statute is this under? Because it doesn't say that we can deliberate on labor negotiations. It states we can deliberate on a labor contract offer and formulate a counter offer.
Right,
Which I realize, and maybe it's just me overthinking this, because to me negotiations is we're at the table and we're going back and forth.
yeah,
Yeah,
that's not how this works.
no, but
Yeah.
that's, I mean,
It can work that way, but we don't do that. So our negotiation is when the IBB team is done and they bring, here's what the team agreed to, can it be ratified? And they bring that to the board, then,
yeah, but what I did not appreciate, and I
Uh-huh.
don't know where it's supported in our in our policies, I guess, not
Oh, uh-huh.
statute, is like what happened was they came and it's like, well, I'd like this changed, and they're like, oh, well, we can't change anything because everybody's voted on it.
yeah, we could have changed that.
So that bothers me.
Yeah,
I
that's,
mean,
well,
because it never came back to us with any of the like, hey, I really would like this
Right.
changed, the language changed.
right,
So we've never seen it. I don't know that it even happened, and
Okay, I have input on this because I went to Brooke, sorry to interrupt,
Yeah.
but I went to Brooke afterwards because I'm trying to keep track of all those pending things. And I went to Brooke and I said, hey, do we need to then get the new agreement because the board agreed to approve it with these changes? And she said no, because it was approved. So I'm
well,
sorry.
no, we need to have the document.
Well, according to Brooke,
so we missed a part that, I might have missed that meeting, we missed a part, 'cause I think I was sick, I missed one of the IBB meetings, or two of them.
Right.
So then you're telling me that the board didn't ratify, meaning the board didn't approve the first document that was brought to them?
There were changes that
Okay.
I wanted in it,
Mm-hmm.
specific to, I mean, just the basic language they were using, which I'm like, holy Moses. So that's where I don't like this whole, well, they've approved, the whole thing's been approved and they don't want to have to go back to their people. So they agreed to make changes because it wasn't necessarily changing the
It
intent
was
of
just
the agreement.
Right, just the language,
Correct.
right.
And
So
yet
it was an administrative thing.
is basically
Right.
yes.
Okay.
But because I did bring up a couple things that I was like, well, I don't really like this, and they're like, whoa, you know, we can't make changes because we've already voted on it.
No, that's exactly
So-
what this is saying, you can't.
Okay.
You
Okay.
can do the changes, that's exactly what this is. Even though it's not a, you sit on your end and we'll sit on, even though it's a more of a group effort, can't
Right.
think of the word, right, collective bargaining,
Right.
right, interest-based bargaining, this still applies. Because
Okay.
at the end of the day, it's still up to the board to decide how the board's gonna spend the money and what they're gonna pay.
Right.
That's all falls upon the board. Unfortunately, some of that was lost in translation somewhere, and I don't think it's just this district. I'm learning that other districts, so I think it's been part of the training or,
Okay.
you know, however it goes, but the statute's very clear that that's all belongs to the board.
Okay, then I think the board needs to be more actively involved in this interest-based
Yeah.
bargaining
Right.
instead of just one or two members.
Well, and that's the thing is the statute, and I know that when that came up at the meeting, my point and even with Trustee Jones was that we need to follow what the statute says.
Mhm.
And the statute says either the LEA has to petition the board for a meeting, or the board petitions the LEA for the meeting. Along with that petitioning, they have to provide the documentation that proves that within the last 2 years, they maintained this level of, paying members.
Okay,
You know, I mean, that's just what the statute says. It wasn't
Right.
like we were digging for something.
Right,
But if we're gonna
right.
do it, let's start doing it how the statute says to
we
do
need
it.
to do it that way.
So that is what this is saying, so that should have happened when the board decided, even if it was an administrative change, the board still should have approved, because ultimately it's the board's contract with the staff, you know, or their organization, you know, their union or whatever, however they refer to themselves. Yeah, so that's the thing, there's just been this, and the statute's very clear, I think, even as Rosanna's learning all of the responsibilities of the trustee, is more than, what most people, think it is. Cause here's the thing, is everybody always forgets, is that the board is the people's voice, right? They're the only thing between the education system and the people's money, you know? So ultimately, it is up to the board to decide how the people's money are being spent, how the people's children are being educated, you know? That's why the board is put in place. Otherwise, there would be no voice for the people in their.
Right. So I don't know if we need that section or not. If you think it's sufficient as it was, just labor negotiations.
Well, we can always put it out there and see what people think the board may still deliberate. Yeah. Labor. Yeah, which basically that is the way it happened even with the IBB team. It was just more of a more friendly approach, I guess. I guess it used to be very contentious.
Well, and I'm not anti-friendly. What bothers me is this whole concept that
Well, that's their characterization of it.
one person who cannot represent, or in
Right.
this year's case, two people,
Right,
you're not representing the board.
Right.
You're just
can't
there
do that.
learning. Yeah.
right.
And so that
We can give an opinion of, oh, well, I think, you know, maybe the board may go for this, or,
Right.
you know, no. Or if the board, you know, if the board I knew that the board said in a meeting, you know, blah, 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 whatever,
Right.
you know, we want pink sidewalks instead of gray sidewalks, you know,
Right,
then I would bring that up.
right,
But it would just be inserted, because that is one of the questions we ask is, do we think this can be ratified? In other words, will they agree to it, and do we think the board will agree to it? Well, we can only guess.
Right.
You know,
right.
although they would insist that we are making the board's decision in there, but we're
You guys
not.
can't.
We
It's-
only
yeah.
recommend. That's the only thing any committee can do is
Right.
recommend to the board,
Right.
you know. Anyways.
So,
yeah.
okay. Alright, well, let's not get sucked up into that. So no executive session may be held for the purpose of taking any final action or any final decision except for a determination to place a certified professional employee on probation, and a decision to expel or deny enrollment of a student.
That's what the statute says.
That's what the statute says.
cause it's sort of the way they had it was, yeah, it did not make any sense to me, but I
Yeah.
can be pretty simple-minded sometimes. It just sounded real goobly gobbly, like, what? Just say what you mean.
Right. So taking action on the student disciplinary hearing, it's like, well, we're either going to expel or deny enrollment.
Right.
If only an executive session will be held, a 24-hour meeting, and agenda notice shall include the date, time, place discussed in provisions of law. The board will not change the subject within the executive session to any subject not identified within the motion to enter executive session or any topic for which an executive session is not provided. Okay. So, in my opinion, I think we're good.
Yep, I agree.
Okay.
I just wish that we could, it rolls over that one little spot
What?
to 3 pages, just because if you scroll down a little bit, Rosanna, see, oh, yours is showing a little bit different, but I see you took out some of the gap. I guess it is what it is, it's just.
One,
there's
two.
no-
Shows 4 pages.
Oh yeah, here. Just fix this. It's because somebody didn't put in the count. They just added a number.
Oh, I was like 4 of 3, how does that work?
Yeah.
1 1/3, it's a 1 1/3 page.
Wait.
Yeah, I was hoping to get here a little bit early, but that didn't work. 'Cause I was gonna sit with Rosanna to look at the board book, the layout and the
Oh,
login
yeah.
and all that.
Yeah.
Where is the count?
Maybe if they can change my rights or whatever.
I can do that.
Yeah, and
absolutely.
then I could get in there and play
Mhm.
with it, and then maybe I can show Michelle on the board or whatever.
Yeah.
So if I get a better feel for what it is, then maybe you can make it a little bit better for us. Okay. Is it not working?
It isn't. Where is
Okay.
the whole?
Insert the page count.
I don't have a page count. I've got a page number.
Yep, page numbers, page count.
Oh, there it is.
Oops.
Okay, got it. I fixed it. Okay.
Well, it's like, can't we just take out something and make it roll up? Probably when we take out everything that was stricken, it would,
It'll bring it up.
yeah.
But it also helps if people don't keep putting paragraphs and they just do spaces.
Yeah, it almost needs like it's too full.
Yeah, there's a lot to fix on that, so there's ways to bring it up. But okay, so
It's done as far as verbiage, yeah?
yeah.
Okay, so 1,500 can move to, whatever Lynn's been doing. I'm thinking we're gonna have to revamp our, which we've already talked about, and she got feedback anyways for the, policy committee. Maybe find a day or a time or something after, your life changes a little bit after
Yeah.
the middle of August. And maybe we can get some of the other people, involved, that would be nice too.
I believe 1,400 is good to go. Apparently there's nowhere in statute that talks about,
1,400? I mean 15?
no, 1,400,
Okay.
which was the, board staff communication. And you felt that in,
Okay.
what is it? statute, there was a statute that governed us going into schools. So,
Oh yeah, I saw that, well, I don't remember that, but okay, maybe I did say that. I said our old policy, or we had a policy that said that we would visit the schools once a year.
Oh, we thought it was some kind of legislature or something.
well, this is the policy that says that.
Okay. I don't know then.
It's okay. I wish people would stop using spaces and use tabs. Okay, now I'm happy. So 1400's done. And then
What was she saying that she found? This is what I found, let me know when you're good to send out to parents. Oops.
This is what I found. Let me know when you're good to send out to parents. I think it was the legal reference of district trustees governance of schools. 4140 visitors in schools.
Oh, 5250 staff, oh, I see, that,
Ooh.
this is what she,
That doesn't work for me.
huh, okay.
So this needs to go.
I know, I'm still on a, even last night I spent till, I don't know, fairly late for me, looking for that one portion of statute or about the, and I'll find it again, about the, manuals, approving the manuals.
What?
Well, remember when we were training and I brought that up and I only brought it, it was only fresh on my mind because we were doing IBB at the same time.
Right.
And, but my brain was looking for something else in statute, so when I read it, I didn't bookmark it or keep it. But there was a point that had to do with, the board's responsibility in providing, like health insurances and benefits and, you know, you have to have this written and that written, and there was some kind of, it said some kind of policy manual or procedural manual, or whatever this manual thing that had to do with employees, the board was supposed to approve once a year or something.
Right,
And
right.
the gal emailed me back and said, no, it doesn't exist, but I know it does, it's there somewhere, but it's in some weird spot that had to do with teachers' pay or negotiations or
Okay.
something like that, so someday I'll find it again.
Okay, so the next policy then you guys sent me stuff on was 3320,
Okay.
which we had already updated all of this. What's the, I thought,
Alcohol and substance abuse.
right,
The one that says draft, is that the one we're working off of?
yes.
Okay. Oh yeah, did we cite that statute? I was just reading this statute last night too. Part of it was, I think that, oh yeah, 33-210, okay, we did. Alright, oh, looks like why are my names all over it for everything I did?
And I know I went through, cause we were working on it and then something happened and I think I had time to kill, so I was playing around with it.
Yeah, mm-hmm.
But, oh. Okay.
Also, can we look at, Rosanna, can you bring that statute up, that 33-210? Please, thank you. That's I don't know if that's up to date though. I don't trust their PDFs. No.
Where is it's normally first one.
It's still yeah, try that one. There we go, 210. This says we have to, and this might be what this is, that it is the duty of the board of trustees of each school district, including charter schools, to adopt and implement policies specifying how personnel shall respond when a student discloses or is reasonably suspected of using or being under the influence of alcohol or any controlled substance as defined, Such policies shall include provisions that anonymity will be provided to the student on a faculty need-to-know basis. When a student voluntarily discloses using or being under the influence while on school property or school function, except as deemed reasonably necessary to protect the health and safety of others. Oh, okay. Notification of the disclosure and availability of counseling for the student shall be provided to the parents, legal guardians, or the custodian. Regardless of any previously voluntary disclosure, the school administrator or designee shall contact the student's parents, legal guardian, or custodian and report the incident to law enforcement. Can you go ahead and scroll through it a little bit? That's good. Also says the district's board of trustees shall ensure that procedures are developed for contacting law enforcement and the student's parents, guardians, or custodians regarding, I just lost my spot, a student reasonably suspected of using or being under the influence. District and charter school policies must meet the provisions of And this section shall be made available to each student, parent, or guardian. Is this the part I read where there's another annual notice? Go ahead and scroll down a little bit. if this is it. So reasonable suspicion, and I don't know that we do this. It says reasonable suspicion. It says said judgment shall be based on training in recognizing the signs and symptoms of alcohol and controlled substance use. So unless the staff or whomever, independent contractor, school employee, or whomever, hasn't been trained in recognizing the signs and symptoms of alcohol and controlled substance use, then they don't fall under the definition of reasonable suspicion.
Okay.
It says shall be based on training in recognizing the signs and symptoms of alcohol and controlled substance use. Which one? What?
What's that?
Reasonable.
I was just trying to read
Oh.
where it was that you were Which
B,
one?
A, 5A right there.
reasonable suspicion.
Mm-hmm. The very last sentence said judgment shall be based.
Okay, so right there, I mean, if they haven't had training
Right.
or
Yeah, I don't know how we're meeting that.
right, but if they haven't had training, it would then fall back on the fact that it's bad judgment,
Mm-hmm.
which can get them in trouble.
Right.
So we need to make a note to ask Lisa what we're doing to make sure staff is trained.
Okay. So can we write that 33-210 5A regarding the training of staff to recognize the signs and symptoms of what that subsection of the statute says. Yeah, because it's very clear in there too that once a student has, prior admission or whatever, they can't use their authority to continually suspect or harass or whatever the words are too.
I don't know why it's done this. Okay,
Done
so
all those little.
it's like half made
Oh.
like paragraphs, so I'm not sure what happened there, but so if you go up to the very top, there we go. There was a lot in here that was
Yeah.
fluff. So if we just state use of controlled substance and alcohol is a serious problem in the presence of a controlled substance and alcohol in school, or let's just say and or. Alcohol in school is detrimental to the educational environment and harmful to the health, safety, and welfare of students and staff. It is the philosophy of the district to help those who desire to help themselves. Students who come forward and voluntarily disclose using and or being under the influence of a controlled substance and or alcohol while on school property or at a school function, prior to the district having reasonable suspicion. I mean, is that the district may make recommendations for referral to appropriate agencies for screening and assessment. I don't know that I like prior to having the district having reasonable suspicion, because I highlighted it for that reason. Because it kind of feels like, I mean, if any kid comes forward,
Right.
and regardless if the teacher had suspicion or not, if they came forward,
Right.
they should be commended for that, in the sense of being responsible or it's reaching help. So, because what it said was, where did this come from?
Let's see if that word is, because they do use the.
Okay. So I'd like to take that out. I don't know.
Yeah.
Because regardless if we have suspicion or not,
Right.
I would much rather commend them for coming forward and seeking help.
It also says such policies shall include provisions that anonymity will be provided to the student on a faculty, quote, need to know, end quote, basis when a student voluntarily discloses using or being under the influence of blah, 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 blah.
Okay, so then,
Yeah, and that's the 33-210.
so on here, 33-210, okay, so it is. Okay, so what was, oh, you've got that paragraph here, okay. So do you want to give me that language?
Sure.
Or it's in 33-210?
Yeah.
Let me just copy and paste it.
Yeah, there you go.
Um,
And it's like the fourth sentence down on the fourth line. 1, 2, 3, 4, 5, fifth line, I guess. Oh no, it's down further than that, sorry. I
It's okay.
highlighted all kinds of stuff on that page.
It's all good.
Yeah.
Let me control. You said it's an
Yeah, anonymity.
anonymity.
A-N-O-N.
Okay, so it's only in there once.
Yeah.
Such policy shall include provisions that anonymity will be provided. Okay. Oh, shall be provided to parents and the legal guardian of the child, or the parent's legal guardian or child's custodian. Suspected of using it. Okay, so. Oh, delete that.
Yeah, and then it says we're supposed to develop procedures on how law enforcement and the parent or whomever is contacted.
It's a shall, not a may.
Right.
Okay, on the recommendations for referral.
asking me about, the referral one.
Yeah, just right above, oh, you had wrote may,
Mm-hmm.
and it's actually shall.
Mm-hmm.
And it's in that same section. Notifications of the disclosure and availability of counseling for students, well, it's counseling, it's specific to counseling, shall be provided to parents. Doesn't say anything about it being provided to the student. It doesn't talk about screening and assessment, it talks about counseling. So I don't know if this is accurate. Because it says we shall make a referral for counseling, not screening and assessment. So I don't know. I don't know what we want to do there.
It's sort of written strange, but it must have been amended a couple times. So yeah, we have to, it says notification of the disclosure and availability of counseling. That's
Yeah.
what it says, so that's what we should say. Shall be provided to parents, or legal guardian, da 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 da. So they shall contact, so I guess we do have to put that back in there. Right. So we have to take out the law enforcement may be called, cause it says you shall contact the parents and law enforcement.
Okay. So hang on, I'm still trying to
Yeah.
wrap my head around.
Okay. Yeah, okay, so this has to come out, cause that is what it says. Get rid of that. Wow, I don't know how that air conditioner decides what to do.
I
but
know,
it's like,
it's cold, right?
Yeah.
Even I'm cold.
it gets really hot and then it gets cold and then you're good for a little while and then it's like, oh. It's dropped all the way down to 69.
Oh, wow. You want me to raise it?
Yeah, turn it up a little bit. That would be great. I always forget the button on the side.
Would you just give me some?
Yep.
Because you're amazing.
I am.
You are. I only hang out with amazing people.
Yep. Do you want some snow peas also? Or?
This is fine.
Okay.
Thank you.
Rosanna, you want some?
Oh, thank you. I'm fine.
Okay.
There's another policy that we have that talks a little bit about reasonable grounds to suspect. It gives a definition of that.
Which one is that?
That is policy 3545. Student interviews, I can't say that word. Interrogations
Oh,
or arrests. 3545 does give a description about reasonable, well, they call it reasonable grounds to suspect.
Okay, I'm a little. I think this paragraph was just too convoluted.
Which one is that? Oh, I see.
Yeah.
Yeah, okay. So shall be is in there twice. District shall provide, anonymity shall be provided. Yeah.
What if? What if we take all that other
Yeah.
stuff out? Because we're saying the same thing twice.
Right. Yeah, it makes it, I think, a little bit more straightforward to what it actually says, and that is the feedback that we got. I mean, although we don't start with these
Mm-hmm.
template policies, but that was one thing that parents and everybody said they're too long, you know. So when they say the school administrator, are they talking specifically about the principal, or well, I guess they're not saying the district administrator? The statute says the school administrator or designee shall contact the student's parents, blah, 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 and report the incident to law enforcement.
I think that means the actual superintendent, if it's in statute.
I don't know.
Not necessarily.
Yeah, it says a school administrator, I don't know.
School administrator would be the principal.
The district administrator would be the superintendent.
I don't know that I've read district administrator.
I don't know either.
Yeah, I've always just read the school administrator or the administrator.
Mm-hmm.
What I was trying to understand is over here, okay, so that is right. Notification of the disclosure and availability of counseling.
Mm-hmm.
Right. I don't know if it has to say immediately, but. Parent, legal guardian, or custodian of the student will be immediately notified, and the district will cooperate with and work with the parent in the establishment of plan to assist the student in whatever means are deemed necessary and appropriate.
Yeah, I don't know what all that means either.
The student.
I think we might be able to take all that out. All the way to where it says appropriate. Yeah, because we already said all that and the need to know and.
Okay, so appropriate disciplinary measures may be taken, or may still be taken. Why would there never be disciplinary measures taken?
Yeah, well,
I mean, it doesn't necessarily need to be negative, but.
Right, and I think what we're trying to get at was in the statute, it says, in addition to policies adopted pursuant to this section, students may, at the discretion of blah, 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 be subject to other disciplinary or safety policies regardless whether the student voluntarily discloses or is reasonably suspected, blah, blah. So I think that they're just trying to tell them that, you know, here's what the statute says, but you might also be, you know, there might be some other consequences also.
Okay.
Besides what statutorily, and even the statute says that, besides what they're obligated to do by the law.
Okay. Statute is that?
33210?
No, I'm gonna control V.
Oops.
372732C, what is that?
That I think is the controlled substance, uniform controlled substance. Using or being under the influence penalties. Yeah, this, they can't, well, I say they can't, but they did, but are you reading that if the reasonable suspicion,
Yeah, that's right where I'm at.
yeah, their parentheses are not, congruent with the statute, because reasonable suspicion is not that.
Okay.
It's not based upon reliable information or personal observation. Well, it could be personal observation by staff, trained, by trained staff. But yeah, maybe we should add the definition to there somewhere. Reasonable.
Or
Yeah, see that other one that I was looking at, that interrogations one,
Mm-hmm.
it has a section there that says, in situations where a student is suspected of violating board policy or school rule, the principal or designee may interrogate the suspected student without prior consent.
Mm-hmm.
And it does go on to say, like, that reasonable suspicion could be, direct observations, or the reported observations, or experiences of others.
Mm-hmm.
Talk about common sense conclusion. So it's like two different things, you know?
Yeah, this, well, I know this, unlike other sections of code, this one specifically in that statute gave its own little definition.
Yeah.
It says, for the purpose of this section, the following definition
Mhm.
shall apply. Because especially the reasonable suspicion, and that was one reason I highlighted it, because you know, that could be lots of things, but I'm glad they made it.
Yeah, they gave the definition.
Yeah, and it's, you know, fairly clear.
This is so annoying.
Because you're right, but here's the thing, so you're behind somebody in a car, I don't know how else to say it, you know, and they're not maintaining a lane, right, they're crossing over. You know, I mean, are they having a medical emergency, are they trying to grab their phone and fell on the floor, or are they drunk, you know?
Right.
I mean, yeah, so you have to be careful, even with these things, it's, I mean, the reasonable suspicion could be, you know, maybe they're not under the influence or whatever, maybe they did just drop their phone or.
I'm more concerned about this.
Yeah.
Whatever action is deemed appropriate. Well, who is deeming that? It needs to be in the policy.
Well, I don't even know that we need to say that there, because up at the top we took directly out of the statute that said, students may at the discretion of the Board of Trustees be subject to other disciplinary action. So I don't think we even need all of that. If the district has reasonable suspicion to believe a student is using controlled substance or alcohol, and the student has not voluntarily disclosed such use or influence, I think we already sort of said all that. Maybe we can take everything out and just start the following, or we're getting ready to say it. The following shall be used as a guideline in determining, or a guide in determining blah blah blah. Because now we're going to say we're going to contact your parent or guardian. We have to contact law enforcement. You know, now we're going to go into all of those things. I mean, I think we already stated all of that above, and this drugs thing should be controlled substance, right?
Right.
Oh, I can't do that on here.
Let's just do this, because it's controlled.
There you go. Yeah, I don't have those shortcut keys on this little thing.
I don't have the shortcut keys either on my big thing.
Oh.
I have to keep going up to the format.
Oh.
They don't work.
Oh, because Lenovo, I bet you they use the other keys for, yep, you probably have to do, unless you do, this function lock thing, because they're double programmed,
Oh.
is why. See, the one's for volume,
Right.
and then to get to that, you have to, lock the function.
Okay.
Probably to get to another one. I don't know. You could try it another time and see if it works. But
Sure. Okay, so upon reasonable suspicion, the student will be asked if he or she is under the influence of a controlled substance and or alcohol.
yeah.
If the student admits hold on.
I don't know. We can call it
legal guardian or custodian will be immediately called. The student will be asked to reveal the circumstances involving the and asked if any other students were involved. The incident will be reported to law enforcement when deemed appropriate.
I
Is-
think after reading the statute, it always has to be, it says shall, right?
Yep.
So we don't even get to make that. I think these are the policies that the students and the parents need to be,
Paying attention to?
yeah, well aware of at the beginning of school. It's almost like you have an assembly and say,
Right.
this is what you're gonna be held accountable to, so make sure you're paying attention. Cause our hands are tied, you know? It's like it might seem a little innocent thing or
But
whatever,
isn't this a contradiction? If step 5, the student will be immediately suspended from school for up to 20 days with possible recommendation for expulsion. But up here, we're
you
saying
may.
maybe at the discretion of the board.
Mm-hmm.
So we're taking the discretion, so to speak, away from the building principal.
Yeah, I think this is probably one of those situations where that whole definition we just went through of temporary suspension comes into play. Because what if the
Oh, okay.
act is egregious enough to where the student needs to be removed from campus, or, you know,
Right.
they don't know, I mean, depending on the severity of the situation. Now the 20 days though, that, well, it could be 20 days when you add all of the,
But the school only has the authority to
right,
suspend for 5.
Right.
Superintendent can add 5. The board can add 10, and then
Right.
we're expelled.
maybe immediately suspended from school. Well, it says for up to 20 days.
But that's not accurate.
Mm-mm. Or we can fix it. We can put in there, yeah, there you go. There you go. Perfect. I took that out because it says that we were gonna require the student and the parent to undergo assessment
I don't
and
think we can do
counseling.
that.
It's like,
We can't do that.
we can't, yeah, just like up there where it says we're gonna ask them if they had used or had it's like, well, we can't be doing that either. We
Right.
can't be grilling people to, you know, what are you just gonna randomly pick people? Cause the statute's clear that you can't
Right, target
ask
them.
people that, you know, may have admitted before or what have you. I don't know if I did, the staff members in charge,
Right.
I think it should be the trained staff members, whatever.
We can't search their car, can we? Or can we, because it's on school property?
I think we can.
Because I thought that was part of the problem with some executive session things.
Mm-hmm.
Um,
Those things were out in the open.
Correct.
Yeah.
So that's why I don't know that we can search their car.
Yeah, that's
Law enforcement could.
right. That's why we got into, well, the whole, I'm glad I didn't read this statute last time, and I'm glad we did, because that's why I had highlighted the reasonable suspicion, because I didn't know what that meant.
Right.
Because if the reasonable suspicion definition would have been such as in other legal issues, then yes.
Mm-hmm.
But now that the reasonable suspicion has been clarified, it doesn't pertain to the whole search and seizure thing. So if we go back to, so let's see, did it do any of those that it,
Yeah, there's a policy that says
Oh, yeah.
students are required to unlock vehicles for reasonable inspection when required to do so by an administrator. It's 3450 student vehicle parking.
okay, what is this? Is
Well, that's our
there-
policy, but what's the
that's our
statute it
policy. I was looking for the
references?
statute, there's nothing.
At the
listed.
bottom, there's
No,
nothing?
no reference.
Maybe it was something else I read, maybe I was reading, cause there's been lots of lawsuits over it. Different, and I read so much of it that, kids legal, here we go. There's an actual website that has to do with all the kids, know your rights kind of thing for students. Let's see what's in this.
On the definition for
Reasonable.
reasonable suspicion,
Mm-hmm.
do we want to include or independent contractor of an educational institution? Does that mean like substitute teachers?
Yeah, it could be. Or what about all the other people that we might contract with for services, you know?
Okay.
And remember we had this discussion with something else about what constituted an employee versus a, summertime, I think we get into a lot of that. See, I think they're playing off the whole reasonable suspicion or reasonable grounds type thing, but I didn't know definitely.
C, it's a capital C, that's a lowercase c. Where's the lowercase c? It's 4.
I guess there was a big case, the U.S. Supreme Court in New Jersey versus TLO and subsequent case law. The court held that to be justified, warrantless searches in the school must be based on reasonable grounds at the inception of the search, and that the search must be permissible in scope. Cases reviewed by the court have examined strip searches, sniffer dogs, handheld metal detectors, and routine searches of students' pockets, purses, lockers, and cars. In general, courts have considered most searches permissible when they were not overly intrusive and when there were reasonable grounds to suspect that a student may have violated either the law or school's rules. And then they throw in this lovely thing. Several sophisticated forensic techniques may prove useful in conducting investigations of suspected drug use or weapons possessions on school campuses. Analysis of hair or nail clippings to identify drug users.
Oh my lord.
The use of metal detectors to identify guns and knives, and the use of laser beams and the Tri-S mini metal detector. Other devices include, and then they go on, inspection mirrors, portable ultraviolet lights, non-invasive, non-intrusive search aids, blah, blah, blah. I'm like, my word. So,
So I put in Idaho 3732 or 372732C. I listed that on the bottom.
okay,
And I gave a hyperlink to it.
okay, yeah, good. Yeah, so we should probably know that, if this wasn't already, is this listed in our annual, notification policies? This one, if not, we need to add it
It
there.
states that the board will review this annually.
Yeah.
The district
okay.
shall provide written annual notification
Yeah.
of the voluntary disclosure provision of this policy.
Mhm.
I think it should just be, the district shall provide written annual notification of this policy.
Yeah, because didn't the statute sort of say that we had to do that?
Policy. I think it needs to be in the student handbook. I don't know what other reasonable means means.
Yeah, I don't either.
Okay, and I put reasonable suspicion, the
Mhm.
definition of it, under where we first use reasonable
Yeah.
suspicion.
Oh, good.
And I think I might.
I think that's sort of important that we define that within the policy.
Yeah.
Straight from the
I getcha.
statute.
Yeah.
Yeah, here's a case in point. So it says, even though it seems that the court has been willing, the Supreme Court, to allow schools to conduct searches based on a lower standard, so just a reasonable suspicion, not the probable cause. There have been instances where the justices agreed that an institution went too far. Savannah Redding was strip searched by a school official after a student tip informed the school that Redding may have ibuprofen. So back to the whole I got a tip or your reasonable suspicion is because somebody told you.
Right.
That's not what it, yeah.
I think C needs to go away because it has nothing to do with the investigation. Because we're saying if the student does not admit to the use of a controlled substance or alcohol, a trained staff member continues to have reasonable suspicion, an investigation will be conducted. So this may include, so why would we say the student may be suspended from school pending an investigation?
Yeah.
We're telling them, I mean, they're in the investigation.
Mm-hmm.
Will be entitled to full due process.
Oh, because it says may include, these may be one of those things that.
Yeah, but
Let me go back and look at it. Oh.
yeah.
Yeah, you're saying they are, because this may include. So here's what may be included.
We can't require the student to have an assessment, can
No,
we? So what is this?
yeah, no, that's not what the statute says anyways. I mean, unless there's something that they didn't cite that we're not aware of. But it doesn't say that, it just says we have to give them some literature, tell them here's what's available to you kind of thing. If we require it, we have to pay for it.
Right. Why do we even need this paragraph?
Now, which one are you at?
I'm on D.
D.
I get the student's entitled to full
Yeah, I
due
know.
process.
I mean, did I add that, or where did that come from?
You did add it,
So maybe it was something that
but, well,
Lisa said, or
yeah, I don't know, cause you, well, actually you
or I
formatted
added bullet.
it.
I
Yeah,
added bullet. It was
Yeah.
probably all lumped together.
probably.
So our old one, I guess it looked like said pursuant to Idaho code, da 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 da. Yeah, I don't know why. Because here's the other thing what I don't understand either. This is sort of a weird policy. Is that if you tell us, if you admit guilt,
Yeah,
then we're gonna call your parents and the police and give you some literature and
color good.
see you at a board meeting or whatever, right?
Yeah,
If you don't, now we're gonna, bring out every,
bring out all the guns.
we're
Yeah.
gonna search you, search your car, search your locker, talk to 3 generations back. I mean, we're gonna do all this because we still think that, I mean, why wouldn't, if the student admitted, why would we not still search?
Well, I
Or
think
lock-
because they're saying, I'm on drugs, or I'm drunk, I've been
Right.
drinking alcohol. So they've admitted to it, so we're not looking for it. I think when we're searching them, we're looking
To
for
prove
something
our
to support.
suspicion.
Yeah,
Ah, gotcha, okay.
yeah,
So we're gonna
Which, I mean-
torture you.
Right, because, I mean,
Either
if-
admit or,
yeah, if we suspect and we look through everything, their locker, their car, their,
we can't
everything.
find anything.
And unless we do a cavity search, but, and we don't find anything, well, we can't validate our suspicion.
Right.
So, going back to class, and, we'll go from there. But we are, I personally think, well, we're gonna conduct, an investigation will be conducted,
Mm-hmm.
and the investigation may include, that doesn't make any sense. It should be that, because if it's only 2 points of, we're gonna search and we're gonna call the cops and your parents,
Right.
well, that's not really investigation. The
Right.
investigation is searching,
Right.
but,
Yeah, I don't know, this was I mean, you can see all the other stuff, actually, Lynn struck out, I think, all of that, 'cause she said we already said all of that in our
Right.
discipline policy, there was no need.
right, because we talked about
Yeah,
stopping that we'll just constantly go back to the one policy that we
Right.
can remain in control of.
so maybe we just need to, what would we just say the investigation includes, or we just turn it into a couple of sentences instead of the, cause it wasn't originally, right, so what happens if I take off, oh, that was a will and a may. I don't know where that was, no, where's this at? Oh. It doesn't matter, it's all straight.
So what if,
Yeah, and then what if I just, I'm gonna X out these cause they're all in the, oh, I added a paragraph, put a bulleted list, yeah, if you just. I don't know what this one is.
Right, so if a student does not admit to the use of a controlled substance and or alcohol, and a trained staff member continues to have reasonable suspicion, an investigation will be conducted. A search of the student's locker, desk, car, or any other school property used by the student will be searched, and law enforcement the parent, legal guardian, or custodian will be immediately called.
Yep.
And then call that good.
Yep, that sounds good to me.
Okay.
I don't wanna undo, I was gonna X out all my little stuff I put, but I don't wanna touch any of it, cause now I'm afraid it's gonna,
Throw everything off.
yeah, so
Yeah.
I'm just gonna leave it.
Let me see here. Well, we can just accept him.
Accept them and it won't
Yeah,
mess it up.
correct. That's what I'm doing. I'm accepting all your.
Okay.
Oh wait, that one I think I'll reject it. Okay. Oopsies.
I don't know where that was.
Okay.
Yay.
We're all done. Alright, so 3330 is done.
So we have 1400, 1500, 3330.
Or, yeah, 3320.
I mean, 3320.
Yeah.
Yep.
And that was all y'all sent me on that.
Mhm. Then we have this attendance policy thing to deal with.
I have a fraud questionnaire to fill out. Huh,
Oh,
that's concerning.
yeah. Hmm.
I start having nightmares now. Um, Okay, so that's done. 30/50. Let's look at that one. I mean, I'm assuming nobody has anything else to do.
Oh,
Do you have to go? Oh,
Um,
this is the one with all the
yeah.
alternatives. What the heck?
And this is the one that we kept saying, no, we did this. We
Right.
went over this, but,
Right. So it looks like she may have, well, that's interesting. Maybe not.
I thought last night when I looked that there was, yeah, the draft that they had, it looked like, I thought there was some, comments or something by Lisa, or maybe that was in another one.
I had a note that Lisa wanted us to review the 3 letters in the
Mhm.
Missing Child Act, and that, I think that's attached to that 30/50 policy, yeah.
The, attendance letter itself, the 10-day letter, or?
She said
Oh,
there's
that's
3
interesting.
letters.
Well, there's comments on the draft
Yeah.
of 30/50.
Right, yeah. Yeah, cause I started looking at this last night.
And it looks like it was, according to this, was last revised on 2016. But I'm curious what our, oh, right here, she has it in there. That doesn't make any sense though, because there's nothing on the bottom. This makes no sense. When in doubt, go to the website.
Oh yeah, that's right, cause I remember reading the statute on this and all of the appeals process. It's like, oh, I don't think they let the, oh, where'd you find those letters at?
It's this one, copy of Missing
Oh.
Child Reporting, so they're just all together. I think.
Oh, gotcha,
It's
okay.
Form letter 1, form letter 2, and then the 3rd one. So they're all together. Oh, there's a 4th one.
Oh, there it is. Okay.
I said 3.
Where are these form letters?
They're-
Right here.
Oh, on our thing. Okay.
Yeah.
And I think they also mentioned the trained dog one because they want that person to start the
Well-
school year with a trained dog or something.
No, I'm aware of what's going
Oh.
on with the trained dog thing. Yeah, it's yeah. So let me go to that. Where's Lynn's email to us? There it is. Okay, so there's only the one letter?
They're all in the same, one link with multiple letters in that, multiple pages of letters in that one link.
I've only got one. How did you get, because this is what I.
No, go back to the thing, it's this right here.
Oh, the missing child
Yeah.
reporting? Oh,
Yeah.
I'm up there under attendance
I
letter.
know, I did the same
I
thing.
thought that's what we were
Yeah.
looking at, okay.
Can we not edit this, or?
We need to request edit to access.
Okay. Whoever owns it. I hate when they always say the law says, and then they never tell you where the law is.
Right.
Or 1845:11, one of them says that.
Right. Okay. So
Lynn owns it, she just gave me edit access. She must be working at home.
she's sick. She should be just, relaxing. Okay, so yeah, we have editing.
Cause I gotta put in these page breaks, it's driving me nuts to see.
Okie doke.
Okay, back.
Okay, I'm a little concerned.
About all of them?
Well, no, we're calling 1845:11 the Missing Child Reporting Act,
Yeah, that's what I was reading.
which it's not.
Yeah, I was reading that. No, it's not. It may be at one point, it was at some point, who knows?
Right.
But it isn't anymore. Let me go back over here. The other thing is I can't, What time is the,
1 o'clock.
okay. Why can't I find the page break? Where are they? Oops. There we go. Okay. All right, back to the statute. It says I have 30 days to comply. So I wonder if do they use all of these, or they're just looking to use one of these letters?
She said they use all of them.
Oh, okay.
In a succession of events.
Okay. Oh, I see what they mean. How did this get all funky like that? Okay, now. Oops, no. Ramona. There we go. Okay. They're sort of, oh, I see. So this actually goes back here. So let's do this. This goes here. Right? And this is 4. I don't know why they put that at the top of the page. Shouldn't be in the footer. A little confusing. Oh, that's why they did it. Because it doesn't see. Okay, let's see if we can change this. This. Okay. Else I should go down here somewhere.
Okay, so the Missing Child Reporting Act is 4509, not 4511.
And is that what is it?
Well, actually, 4509 is Missing Child Reports,
Okay,
and 4511 is the school duties
right.
and the records of missing child. So I
believe it's called the Missing Children's Assistance Act of 1983. That's the act. It's a federal act.
well, they're citing state law, so you can't use a federal title with state law.
Right.
So
I think those don't match, is what I'm saying.
well, I think at one point potentially Idaho Code 4511 may have been the Missing Child Reporting Act, but I don't know.
Okay.
It is chapter 45 is in the crimes and punishment for kidnapping. I wonder.
No downloads available. So when was that? Let's see, when was that updated?
Yeah, it's not that. It's not called that anymore.
Okay, 184507. Of Idaho Code may be cited as the Missing Child Reporting Act.
Oh, yeah. So that's why they said that. So 4507, 8, 9, 10, and 11 may be cited as the Missing Child Reporting Act. That's why they put it in there. I'm trying to see the. Oh, that's why, because every school would have their own letterhead. Doesn't that last one seem like it's awful squished together? Oh, there's a whole blank page in there. Let's get rid of that. Which one is it? Number 3 just seems like it's so. The lines are very close. Oh, because it's justified. That's what it is. The top half of it. Don't we have to put, yes. So you're gonna leave that or strike the Missing Child Report Act? It's actually Reporting Act on the top of it.
What are you doing? I mean, where are you at?
On all the letters that have in the parenthesis,
Well, it's only the first one that has it in parentheses.
no, the other one does too. Number 4 has it,
Oh, okay.
but it says Report Act and it's reporting.
Well, if they want to list the Missing Child Reporting Act, then they need to leave it at that and not cite specific code, because that specific code is not the Child Reporting Act. It's all of those codes.
Right.
So,
But it says these sections of the code may be cited as Missing Child Reporting Act. So any of those may be cited as that.
see, and I interpret it that all of those together, 07, 8, 9, 10, and 11, which are all their own titles, that all of those equal the Missing Child Reporting Act. So if you're going to cite the Missing Child Reporting Act,
right.
you're utilizing all of those, not just one or the other, because it's an and. It's all of those titles is the act. That's how I interpret it. Because otherwise, I would think it could say either and or 07, 08, 09, 10, or 11 may be cited as the Missing Child Reporting Act.
Right.
But I think it's all inclusive. It's all of those statutes. And I guess, I mean, they can, because we specifically hold out under 4511, because that's the specificity to the school duties.
Yeah, and I don't know where those letters came from, so I don't have anything to compare them to.
Right, I don't either.
You know, if they were an ISBA thing or a state thing or.
Right.
So should.
Why is that so little?
It's, you know what it is? Yeah, it seemed really squished together to me too. I think that justifying makes it look odd. Yeah, we did it right the first time. I don't know that we necessarily even needed to look at those, but
Yeah, I don't know either.
because it's more of an administrative thing, I would think.
Right. Why is it not going at what happened to form letter 1? Oh, that is form letter 1. Why does it say 2?
I don't know, some are in parentheses, some are not in parentheses. This one just says Form 3. It doesn't have the word letter. I'll put the word letter in there. Has the word letter capitalized, or did they leave it lowercase?
Yeah, I would say, I mean, so basically we're giving them 30 days, then we give them 10 days, then we notify law enforcement, and then if they comply, then we send another letter, so.
Which I think is the way it's laid out from when I was reading.
What's that?
In the time increments in the statute.
Okay. So is there more we need to consider on these letters? I mean,
Yeah, it's pretty much, I mean,
pretty standard.
yeah.
Make a comment to Miss Pasley.
There's something in that statute about transfer students.
Right, yeah, they, you're right, I just read that somewhere.
Cause that mentions something about 14 days of transferring.
Right. That they will request records from the prior school, certified copy.
That's interesting.
remember
Okay.
reading this.
Huh?
So I don't ever remember reading this policy, memorial guidelines.
Mm.
I'm looking to see if I can find in the old, agendas a 3050, but you know, it could have been renumbered too, and unless we knew what that number was, it might not show up. So I was trying to see when that was, if I could find the one that we may have worked on in there.
I'm pulling up what Chrissy had to see if there's any comments or marks on them, because it appears on September 3rd.
Mm-hmm.
But that was like right before she left. That's weird.
What did I see?
And I know we worked on it before. Oh, so what is this one? Maybe.
Yeah, and the one thing that also stood out to me too was they all caps, the only absences that will not, all caps in the policy. It's like, I know we redid this one. But I guess we'll just have to do it again if we can't find it. Yeah, and then I remembered this too, this whole, flow chart of how it worked.
Okay.
But maybe we started it and then that was the end of it, or, I mean, who
Yeah,
knows?
it might have been a. It might have been a. We're moving on.
Yeah. Oh, and then there, so Chrissy had an alternative in there also.
Right, that's what I thought was interesting.
Yeah.
Is and then these are dated back in May. On the one she has highlighted draft,
Uh-huh.
Ryan made some comments, or Ryan made a comment. I should say
Uh-huh.
he made several, and then Lynn made comments
On the draft.
on the draft,
Yeah.
and this
Mhm.
is in May,
Mm-hmm.
which. So maybe I don't know. Maybe we looked at it back in May, and here we are in July.
Yeah, could be,
I don't know.
which is alternative 3, is that the one you're looking at the top? Yeah.
Yeah. Which I don't know.
Yep, I see you there.
Yeah.
So this is not the current, oh. I'm so confused.
If you pull up the Janelle one, which is a Word, not a Google Doc,
Uh-huh, that's ours.
right, that is
Mhm.
ours.
So why didn't we just start with ours instead of this alternative 3 that they, cause it already has 90%. This was the same one that, Lisa was talking about the other night. This one has 90% of the time, no
Right.
more than 9 days per semester. They have to be, doctor excuses, blah, 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 blah.
Right.
So I think maybe there's confusion over between what they were looking at and working on versus what, because that one that they made notes on had some 40, what was that? Oh, credits and 65% mastery.
Right. Well, maybe we need to make sure Lynn's here to understand
Yeah.
why she created
Yeah.
this draft on part
Yeah.
3. And there's 4 different recommendations, and why we didn't just start from our old
Yeah.
policy.
Yeah, 'cause I can see some remnants of it, like the only and the will not. And then they delineated the types of absences. Yeah, I agree. I
Okay.
think it's too involved to just, and then we're just wasting time doing something that's not gonna be useful.
Correct.
Okay, they have a potluck
Oh, they do?
at 1.
Oh,
Mhm.
well, let's skedoodle on out of here.
I might hang out, see what they have. No.
Yeah, for sure.
That's fine. I'll just be able to look and smell. I won't be able to taste. Well, I can't really
Oh.
smell much either, but
So if we want to go ahead and stop recording.
Yeah.
Okay.
so it was pretty good. We still got 3